15th, which we did. On December 15th, we filed a brief addressing the issues of whether or not Vanguard was, quotes, on notice of fraud claims. At 11:56 p.m. that night, for the very first time, we received the petitioner's motion for leave to file an amended petition. We then filed opposition to that, which was delivered to the court on or about December 18th, before the hearing on the 19th. The issue, Your Honor, before us is the fact that plaintiffs are pursuing two separate theories for fraud. The first theory that they had for fraud was that we were on notice of it given the allegations in the first amended petition. If you take a good look at the first amended petition and the fourth cause of action, at best, it alleged fraud in the inducement. And the fraud in the inducement occurred before Vanguard was even involved in the matter altogether. So for that instance alone, that theory of pleading should not go forward at all. Then we move to what became the, quotes, non-binding letter of intent issue, which now forms a basis in part for the second amended petition, which is clumped into the same fraud cause of action. It is unclear in that fraud cause of action now the impact, the implication, the effect of the LOI. In addition, the parties have been engaging in discovery, which we were. So yesterday, we deposed the broker who wrote the non-binding letter of intent and the prospective purchaser. I received their deposition transcripts this morning. The way the second amended petition right now is currently framed, if we move forward as alleged, we will be severely prejudiced to the extent that we will be unable to have a sufficient opportunity to challenge the allegations, to move forward and provide an effective defense at time of trial, which, as the court knows, is next Tuesday or a week from today. In addition to that, when we were here on December 19th, you brought up the point about whether or not I would request a trial continuance. And to that point, we did bring that issue up in our brief that we filed on the 15th of December and our opposition that we filed on the 18th. So the problem that we face right now as a defendant is we have new fraud allegations based on new facts in part and on old facts which don't state a cause of action altogether. If we move forward right now with the second amended petition, there is absolutely no way we can move forward with the defense at trial. We will move forward without a trial continuance on the grounds that it's going to be trial by fire. One other point that I think is worth noting, the non-binding letter of intent was also the topic of a motion in limine that we made, motion in limine number 10. Since we filed that motion in limine, we did depose, as I just mentioned, the broker who prepared it and the prospective purchaser. So we have new facts now that we can add to and challenge whether or not the LOI itself is even admissible at trial. One more fundamental point that we have is that if we move forward without a trial continuance, we are being denied our due process rights as a defendant in this case to challenge the second amended complaint in an efficient and effective manner. And with that, I would submit it, Your Honor.
All right, Mr. Hare, do you have anything you wanted to add before I turn to the petitioner's counsel?
No, Your Honor.
Mr. Ruel? Ms. Rowan?
Thank you, Your Honor. Court has authority under Code of Civil Procedure 473A1 and Code of Civil Procedure 576A to allow amendment in furtherance of justice. Here, it is in furtherance of justice to allow amendment at this late stage, in large part because the new facts are arising are facts that were not known to Dr. Keyes, but have now been demonstrated that they were known to Vanguard and to Edwin Davidian, and it will be shown that they were also known to Dr. Baradnia. So in terms of furthering justice, if the only person in the room, the only party in the room who didn't know about these facts was Dr. Keyes, and now they come up on the eve of trial, allowing him to amend his pleading to allege those facts and a modest expansion of the fraud claim to include constructive fraud against Vanguard, the fiduciary duties of Dr. Keyes, when they knew about the letter of intent. They knew Mark Gettyman transmitted the letter of intent to Ollie Rismonchi at Vanguard. That's the evidence that recently came up that we did not know about, but Vanguard did. And as such, it does further justice. In addition, late last week, I attempted to meet and confer with opposing counsel, Mr. Montaneri, to discuss any challenges he may raise to the amended pleading, the proposed second amended petition. I invited discussion on any terms, any perceived defects that he believed were in the pleading, and I attempted to address those. He didn't clearly articulate what all the grounds were that he would demur on, although he expressed a general intent he would demur. So we've made efforts to meet and confer, in Your Honor, allow pleading.
All right, thank you, everyone. Respectfully, folks, I do find that allowing for the second amended petition to be filed and heard would be in furtherance of justice, and I'm going to grant petitioner's motion to file that second amended petition. I think kind of the gross summary of my thinking on this is that Vanguard has been this document, at least constructively, the entire time. And because of that, I don't think there's any undue prejudice to Vanguard to allow for the amendment at this time. I recognize it's late, but everyone's been talking about this for a month or so at this point. So there's been time for Vanguard to prepare. And really, when you think about it, it's Vanguard's document. Their agent had it. They're on constructive notice of it. And it was never disclosed to the petitioner. Once it came out in kind of a weird way, but once it came out, the effort to amend was made promptly. I think that the second amended petition in the furtherance of justice fairly adds details as to Vanguard's alleged fraud. It does expand the fraud allegations that Vanguard was already on notice of from the first amended petition, but it's a fair amendment. And again, this information only came to light recently. And on some level, the fact that, and I am concluding that Vanguard was on notice in the First Amendment petition that they would have to defend against allegations of fraud, maybe fraud in the inducement, but fraud nonetheless. The circumstances here, I think it's only appropriate to allow for the filing of the Second Amendment petition, so it may be filed. The court is happy to hear any challenge to the Second Amendment petition that might be made by any of the parties. So that motion is granted. In terms of what I think now is going to be Vanguard's formal request for continuance, Mr. Montanari, I don't know that there's anything more to be said, but I'm happy to hear from you if you want to flush out that request at this point.
No, Your Honor, it goes back to my original point in that the allegations in the Second Amendment petition remain unclear. We were being denied due process to effectively and efficiently challenge those allegations, and in a timely manner, considering our trial is set to start next week. As it sets right now, we are still taking depositions. We have the deposition of Edward Davidian that's set for this Thursday. I know the court had set a deadline for him to be deposed before December 30th, but his counsel's been playing games with us and stalled the process. We will be filing a motion in that regard as well. So as we sit here today, we still don't have all the facts. And with that being said, in fairness, and not to deny any due process rights, a trial continuance is definitely in order to give us the opportunity to challenge the pleading in an effective manner, rather than go to trial and shotgun approach it in front of a jury or in a series of maybe motions outside the presence of the jury.
Mr. O'Hara, anything to add? Do you support the request for continuance? Or do you oppose it?
We have no position on the request for continuance.
Petitioner?
Your Honor, we oppose the continuance. There's been ample time for discovery. In addition, Vanguard and Dr. Barania knew about this letter of intent. Edmund Davidian's deposition is going forward this Thursday. There was substantial back and forth around the holidays about scheduling. My impression of the efforts to offer dates, Davidian's counsel appeared reasonable, so I disagree with the characterization that he played games anyway. He'll be deposed this Thursday before trial, so I don't think there's any undue prejudice. So we oppose the continuance.
Thank you. Also, respectfully, I'm going to deny the request for continuance. If there's any pressure on Vanguard to be ready for trial, I think that's been alleviated by the length of time we've been talking about this. It's been at least a month, if not more at this point. I understand things are happening at the last minute, but sometimes that happens in trial, particularly as the court has already articulated in a case where, you know, I don't cast any aspersions to you, Mr. Montanari. We have had other cases together, and I have great respect for you, but and I know you came into the case later, but the fact of the matter is this is a conundrum of Vanguard's own doing. I strongly at this point believe that the discovery that's happening at this point is happening only because this letter of intent was not disclosed previously. It only came out at the last minute. I don't think there's much more to say about it, but I do not find there to be good cause under the different factors in the rule of court to continue this matter. So the request is denied.
Your Honor, we would respect the request to stay of this action under California Rule of Court, Section 3.515, so we can seek appellate review of this ruling. Also, the court has the authority in the interest of justice to stay the case in accordance with the holding of Freeburg versus City of Mission Viejo, 1995, 33 Cal. 4th, 1484, and Cottle, COTTLE versus Superior Court 1992, 3, CalApp 4, 1367.
Did you cite the court to rule of court 3.515, counsel?
Yes.
I'm just looking at the title of the article within which that rule falls. And it's called Procedural Rules Applicable to All Complex Coordination Proceedings. It seems like that rule might be specific to a kind of case of which this one is not. Do you disagree with that?
Do,
Why?
because it's a general authority for a court to permit the stay of a case at the civil court level, superior court level, so that it can be reviewed at the appellate court level.
Not really deal like that says with Judge Sweet also. I think that man harassed me for a acre. Family law. This is family law. Oh my god. Oh, look at this. This is that Judge Schurz I want to sue. This is not sure.
it's requesting that he pay credit card bills, utilities, and mortgage. And yet you have joint accounts. So explain to me how that's going to work prior to.
Well, according to my client, he's moved all of the money out of their accounts, so there's no active.
There's no access to any other money.
Okay.
I see. Okay. These the debts that you had asked for payment on were due in December, I note. Okay, I assume that at least some of them are recurring costs. Okay. We're now at the 1st of January. Do you have any updated information about costs that you would need him to pay?
Well, our monthly expenses are approximately $10,000 a month. And I have some private funds in Minnesota that I've had to go to pay some of the bills. Some of the bills are still outstanding. So yeah, it's not a very good situation.
Judge, did you want me to swear in this? Since you're.
In a moment. I just want to get the background first. And let me ask you about the car. That's listed. You're both registered on it.
Yes.
Okay.
The BMW?
Yes.
Yes.
All right. So actually, I'm gonna swear you in just so you can give me those facts. The clerk will swear you in.
You can remain seated. Do you solemnly state that the testimony you shall give under penalty of perjury shall be the truth, the whole truth, and nothing but the truth? If so, please swear to you.
I do.
Thank you.
And can you state your name for the record, please?
Deborah Ann McDonald.
Okay, so Ms. McDonald wanted to just clarify a few issues with regard to finances. You stated that you have a car which is described in the papers that's registered in both of your names. Is that right?
Correct.
Okay, and you're asking for exclusive right of
Correct.
control of it?
Right.
Okay, and in addition, you indicated that there are costs of about $10,000 a month that you're asking that Mr. Hyman be ordered to pay because he has essentially moved community funds into a separate account.
Correct.
Okay. Can you tell me what he's moved from your joint accounts into a separate account?
There was about $14,000 or $15,000 in the checking account, and there was $2,000 to $3,000 in our business account. Normally, what happens is to cover the $10,000 a month, we have investments of one sort and or another, and so he moves the funds from the investment accounts into our joint checking accounts. But now he hasn't done that, and also he's taken all those funds.
Okay. Anything else you want to add on that?
And yes, Your Honor, I'm not able to access the investment accounts.
Or is that a joint account?
It's community funds, but he's the only one that can access them.
When you say they're community funds, that's actually a determination that has to be made down the line, but you mean it's in a joint account?
No,
No. Okay, it's in his name only?
yes.
Okay. Do you have the account information? Okay,
For one of them, just one.
all right. I think it would be helpful if you can pass that forward. I'd actually like to identify the accounts in the order, in the event that you need to serve it on a bank or.
And we can know it's you.
Yeah. And what you've just handed me is what?
That is an annuity account.
Okay.
Fidelity.
And, but we've talked about some separate accounts and joint accounts. Which account is that?
The only accounts that I am on are our checking account and our business checking account
Okay,
jointly with.
okay. So the annuity account is in his name only, and it's the account that, one of the accounts that you use to pay your monthly expenses.
Correct. Originally, Your Honor, the monies were mine, and he and a friend of his kind of tricked me, if you will. And so then it was only in his name, but the original investment was $50,000 of my money.
Okay. And do you have the mortgage and utility and credit card information that you can?
I don't have it here.
Okay.
But I do have it.
All right.
Yeah.
Well, what I'm inclined to grant the request. I'm trying to make it as specific as possible in the event that you do need to serve a financial institution. But
Well,
I know that you're going to serve him probably soon, at which point there will be a restraining order on assets at that point. So that should also hopefully help with the situation.
I can give you the names of, the mortgages with PennyMac, the major credit cards are US Bank and American Express. But I don't have necessarily.
Okay.
Big experience. No, no.
So I think this is actually going to take us a little bit longer than we thought to produce the order. You're welcome to wait around. As you know, we have a long cause matter that's going to be heard shortly. So I don't know that we'll get the order out this morning. We'll certainly get it out today.
That's fine. It could be sent by email. Your Honor?
Absolutely.
That would be
Will you
great.
stipulate to that?
We would stipulate to that.
Okay.
And do you want to ask any questions about the attorney's fees?
I'm going to review that right as we speak. Okay, I've reviewed the invoicing. I'm prepared to grant the attorney's fees as requested.
I would add $1,000 to that amount, which is 2 hours of my time, to the $6,129, which I believe is the amount. So we would ask for $7,129 as the award for attorney's fees.
Those 2 hours being this morning's appearance?
Correct. Well, I prepared before this hearing as well.
Okay. All right, well, I'll grant the request.
Thank you, Your Honor.
So the total will be $7,129.
Thank you.
All right. So if you stipulate to emailing the order, we'll get that out to you later today. There'll be some specific findings in it relative to our discussion. So thank you for your patience and good luck to you.
Thank you, Your Honor.
You can do it back here. They're gonna send like email or.
Oh, you still want this?
Yeah.
Okay, perfect. Sorry about that.
No.
It's so our system's open, and this,
That's the end of the.
not for that. It's very basic what courtroom clerks can do with it. Is the Adobe that we have is like the basic, so it won't allow us to scan it and save it to the system. It only allows us to scan it and save it into.
Oh, well, that's okay. Scanning into, oh, no, we don't want that in there. Yeah, okay, I understand. All right.
Oh, and Judge, the Melissa, I believe that's Melissa Naftel, so if you wanna.
Oh, okay.
The LeClerc matter
Yes.
versus Naftel. I think hearing.
Mr. LeClerc,
Yes,
Miss, is it Neftel?
NAFTA.
Naftel, has appeared by Zoom, and although she's late, given the issues we discussed about the property, I think it would make sense to recall the matter and have her be heard. So if you can come forward, please. Good morning, Miss, is it Neftel?
Yeah. Naftel.
Okay, can you hear us okay?
Yeah.
All right.
Wow, my lighting is way worse.
We heard your matter. And I granted the restraining order. That was a 9 o'clock calendar. I understand that there's still some property left at Mr. LeClerc's residence.
Yeah, I haven't had a chance to go get it, and I also, I tried to submit it online, but I was having problems with your e-portal, wanting to file domestic violence, personal injury charges or lawsuit against him, which I did email to you guys last night. I couldn't submit it on your e-filing portal.
Well, this is a domestic violence restraining order proceeding. And so the only thing that we're here to decide is whether or not the allegations of harassment were sustained. So if you have other claims that you feel you need to make, you have other avenues to do that. There is a legal self-help office at the court. You're welcome to go there, but this proceeding is just about the request for the restraining order, which I found there was sufficient evidence to grant. And you may recall there was a carve out to allow you to obtain your belongings. So are you still intending to retrieve your belongings?
I don't have a way to as of right now, because of like financial abuse and other things. Part of them related to this, but on the domestic violence, which is, Mr. LeClerc's fault, I wanted to request that he pay for me to stay somewhere or a storage unit for the belongings.
So you have a mechanism. You can call the sheriff's or the police department, and they will accompany you to obtain your belongings. There's no cost to that.
But will they pick me up, and where will I put the things in the interim?
That's up to you. But
well,
I'm
that's
just
what I was going to request on the domestic violence against him.
okay. Well, that's not for this proceeding. So I'm just letting you know that the restraining order has been granted. There is an exception that you're allowed to retrieve your belongings, and I would encourage you to do that. You can call the sheriff's department, or you can call Sausalito Police, and they will accompany you, and you won't be in violation of the order. If you have other legal claims or concerns, then you can go to legal self-help and see if they can assist you in filing those, but that's not part of this proceeding. Okay?
Okay.
All right. Well, thank you for being.
I am curious. I couldn't get the documents, but I'm curious as to what harassment evidence there is.
So you were served with the petition, and that the allegations are in the petition. So you have notice of them.
I don't have the paperwork, and I have been requesting party access, but they have been harassing me about an address. because apparently you guys don't have my address, so I can't have access to the documents online.
So there's a proof of service on file showing that you were personally served with the papers. So you have the information in the restraining order request, and that's the basis for the order, and that's the order that I've granted. So you're welcome. If you need another copy, you can come to the clerk's office and request them to print you out a copy, and I'm sure they'd be happy to do that.
Can they email me one? So my issue right now is lack of transportation because of
I understand.
domestic violence and blackmail by Dave and Wes Renzis and my sister.
So if you would like, we can email you a copy of the order that's been
Okay.
granted today. Do we have an email address on file for you? All right.
Yeah.
We'll email you a copy of the order, so you'll have that for your records, okay?
Okay.
Great. Well, good luck. And we'll send you a copy of that today.
And what is going to happen to my belongings? Some of that is legal evidence for a federal lawsuit. I do not want him to be tampering with evidence.
So you have the right to go and obtain your property or ask someone to do it on your behalf. That will not be a violation of the restraining order. How you do that is up to you.
Okay.
All right.
And until then, he is not to touch any of those things because that's legal evidence. Would be
Well, I
tampering
don't
with
know whether or not it's legal evidence, but it's your property. So,
well, it
you-
is, and there are different things for different lawsuits. So
right. Well, you should go and get it then. It sounds like it's important information, and you should
yeah,
get the civil standby process.
but he's apparently taken photos of my personal private info, which was recorded on that last meeting here.
So also, you should know in the order, you have until the end of the month to get those materials because the carve out is going to expire at that point.
Is that the end of this month, January?
That's correct.
The date would be the 30th,
31st.
31st?
Yeah, we'll send you that. That's going to be in the order, and we'll send you a copy of that so you'll have it by email.
Okay.
All right. Good luck to you.
Thank you.